of guilty to count 1, aggravated statutory rape, Class D felony, and see the sentence of 2 years to serve in Tennessee Department of Corrections as a range 1 offender. That will be consecutive to counts 3 and 4. He'll be required to be on the sex offender registry. Count 2, it would be a sentence of 2 years to serve, aggravated statutory rape, to serve in the Department of Corrections as a 30% release eligibility. That will be concurrent to count 1, sex offender registry. Count 3 is sexual exploitation of a minor. He would receive a sentence of 3 years to serve in Tennessee Department of Corrections as a release eligibility of 85%, and he would be on the sex offender registry. Count 4, sexual exploitation of a minor. He would receive a sentence of 3 years to serve in Tennessee Department of Corrections. That would be concurrent with count 3. He would be ordered to pay the court costs. This plea would be final with no withdrawal or appeal. Mr. Tomlin, raise your right hand and let's place you on the oath.
Yes, ma'am.
State your full name for the record.
My name is Troy Allen Tomlin, Jr.
Mr. Tomlin, you and I have some history. You've appeared before me on a number of cases. I want to make sure that we understand each other. You appeared before me, for example, on one time wearing a Spider-Man outfit underneath your clothes because you were headed to Comic-Con in Nashville, and I did not allow you to go because you were facing these type of sexual charges involving minors.
Yes, and I apologize for that, sir.
That's all right. I just wanted to make sure that you understood that I remember your case well. And you entered a plea previously in this case, and then later came back in and wanted to withdraw your plea. You understand that?
Yes, sir.
You understand that this go round, you've got not 1 but 2 of our finest criminal law attorneys who are representing you, one on either side of you, supporting you, defending you, and giving you advice, and that they've worked out this plea, and this is going to be a final plea. Do you understand that? You're waiving your right to appeal, and that this court will not consider any motion to withdraw your plea after today. Do you understand that?
Yes, sir.
And well, I might have to consider it, but I'm not likely to grant it. And you're raising your hand. That's not a good thing.
I was just trying to tell you that I'm just tired of losing out.
Right out of the gate, this case is already taking a serious turn. The defendant is pleading guilty to multiple felony charges involving aggravated statutory rape and sexual exploitation of a minor, and the consequences are significant. We're talking prison time, mandatory sex offender registration, and a plea agreement that specifically limits future appeals and attempts to withdraw the plea. That's a huge legal commitment. The judge is making sure every detail is crystal clear because once this plea is accepted, there's no easy way back. And here's the question for you. If you're facing charges this severe, would you risk going to trial, or would you take a negotiated plea deal like this one?
I want to do better.
All right. Well, this is to give you an opportunity to do that. So, do you understand everything you're charged with? Do you understand what the range of punishment is you're facing? Have you and your 2 lawyers been able to discuss this case fully with you, and you all discuss what the range of punishment is and any possible defenses you might have?
Yes, sir.
Well, it's indicated that you want to enter a plea of guilty. Do you understand you have a right to plead not? Did you turn that microphone off? Do you understand that you have a right to plead not guilty and to have a speedy and public trial by jury?
Yes, sir.
You understand that if you went to trial, you would have the right to have a lawyer and have one appointed if you could not afford your own?
Yes, sir.
You understand that if you went to trial, you would be presumed to be innocent until such time if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of. You understand that if you went to trial, you and your lawyer could confront and cross-examine every witness the state called to testify, and you can bring in your own witnesses by the use of a subpoena.
Yes, sir.
You understand that if you went to trial, you'd be presumed to be innocent. You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify in your own trial.
Sir.
You understand if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to appeals and have a lawyer appointed to help you with this appeal.
Sir.
You understand that you went to trial. By entering this plea, you're waiving your right to a trial and to an appeal, and I will be simply approving what you and your lawyers have agreed upon with the state.
Yes,
as
sir.
a disposition. You understand that?
Yes, sir.
You understand everything I've explained to you?
Yes, sir.
Do you understand this is going to result in there's 4 different felony convictions, and those convictions are going to all be on your record in the future to make more severe the punishment to receive if you're ever again convicted of a crime. You understand that? You understand that's going to require you to be on the sex offender registry, and that means the sex offender registry has certain conditions that are going to have to be met that are in addition to regular probation. Do you understand that?
Yes, sir.
You understand everything I've explained to you?
Yes, sir.
Do you want to waive your right to a hearing according to trial according to this by entering this plea of guilty according to this agreement?
Yes, sir.
Do you understand if you plead guilty, the court of the state may ask you questions about these offenses, and if you answer these questions under oath on the record in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if we find that you were lying under oath?
Yes, sir.
Is your decision to plead guilty today voluntary?
Yes, sir.
Anybody forcing you to do this against your
No,
will?
sir.
You understand that I cannot accept your plea unless I'm satisfied that there are facts to support it and that you are in fact guilty of these charges.
Yes, sir.
Now, I'm going to ask this question of the lawyers. Is this a best interest plea where the state is required to provide me with a factual basis?
Yes, sir. He's got some limitations as the court knows.
Well, we've already had an evaluation
Yes.
performed under a court order
Yes.
evaluation. He was found to be competent to stand trial and found that there was no defense of insanity available to him
Correct.
under that evaluation.
Just
so-
don't think he could articulate answers. Ready to ask him, and I would ask the state to let him.
All right. Let's let the state, if do you have the opportunity to lay a foundation for me factually?
This case will proceed to trial. The proof would show that in March of 2022, Mr. Tomlin had sexual intercourse on 2 different occasions with a victim that I'll refer to as JB. JB was 14 years old at the time. A subsequent interview with police, Miranda.
This is one of those moments judges take very seriously. Notice how the court isn't rushing through the process. Instead, the judge is carefully confirming that the defendant understands every constitutional right he's giving up. The right to a jury trial, the right to confront witnesses, the right to remain silent, the right to appeal. These aren't just courtroom formalities, they're some of the most important protections in the entire justice system. The judge even references previous appearances, showing just how long this case has been working its way through the courts. What stands out to you here? Does the defendant seem fully committed to this plea, or do you think there's still some hesitation beneath the surface?
Mr. Tomlin admitted to having sex with JB on 2 different occasions. A phone dump was done of Mr. Tomlin's phone in which a photo of JB's breast was located, which would constitute child pornography under TCA code, and a video of JB dancing nude in the shower.
All right.
This happened in Dixon County.
Thank you. Mr. Tomlin, do you understand that's what the state's evidence would be if this case went to trial?
Yes, sir.
All right. You still wish to plead no contest according to this agreement?
Yes, sir.
Are you satisfied with your attorney services? You've had not 1 but 2 lawyers representing you now. You believe that they've done a good job representing you?
Yes, sir. They did an excellent job.
All right. Mr. Flanagan and Mr. Wenning, do either of you know of any reason he should not enter this plea? Anything further from the state? Well, this disposition is at the victim's request. All right, so that the record reflects the victim in this case has requested this disposition of the case. All right, then Troy A. Tomlin in docket number 22 CR 319, upon your plea of guilty to count 1, aggravated statutory rape, I find you guilty, sends you to 2 years to serve in the Tennessee Department of Corrections as a release as a range 1 offender. Count you're ordered to attempt to enroll and comply with the sex offender registry. Count 2, you're found guilty of aggravated statutory rape, sentenced to 2 years in Tennessee Department of Corrections. That will also be served concurrent to count 1, and that will be on the sex offender registry as well. Count 3, sexual exploitation of a minor. That will be sentenced to 3 years to serve in the Tennessee Department of Corrections as 85% release eligibility, and you will be required to be on the sex offender registry. Counts 1 and 2 will be served consecutively to this one for an effective 5-year sentence to serve. Count 4 is sexual exploitation of a minor. He's sentenced to 3 years to serve in Tennessee Department of Corrections, release eligibility of 85%. That will be served concurrent with count 3. Again, he will be required to attend the sex offender registry. He'll be ordered to pay the court costs. This plea is considered to be a final plea. All appeals are waived, and there will be no consideration of a withdrawal of this plea.
Judge, we will submit an agreed order with jail credits. There was something.
That's fine. Jail credits will be submitted by an agreed order. Thank you.
You took that man's stuff and you went to try and take money from his debit card. You remember that?
Yes.
And it failed, right?
Yes.
And then you saw this 22-year-old lady, Miss Brooks, with her mother. You knocked her to the ground and you tried the same offense again, right?
She wasn't with her mother, but yes.
Still a 22-year-old lady. Still somebody that you knocked to the ground, put a gun to her head, did the same thing again. Right?
Right.
And whenever all that takes place and the officers finally get going, their reports, which your lawyers had access to, and I'm assuming you've had an opportunity to review, say that you were going over 100 miles an hour in an effort to evade them. Right?
I don't remember nothing that's what's wrong.
Definitely well in excess of the speed limit, correct? You're doing everything you could to get away from it. Right? Just like today, you're doing everything you can to try to make sure you get probation, as opposed to, I'm going to ask this judge to give you 15 years, right?
The parties have rested the presentation of evidence. The court has the pre-sentence report that has been submitted by the probation office and admitted without objections.
And there it is, the factual basis for the plea. This is the moment where the prosecution lays out the evidence they say would have been presented at trial. A defendant can choose to plead guilty, but judges still need enough facts on the record to justify accepting that plea. According to prosecutors, there were admissions made during a police interview, along with evidence recovered from a phone. Whether a jury would ultimately convict is something we'll never know because the case won't reach that stage. But hearing these allegations spelled out in open court helps explain why both sides reached this agreement. Looking at the evidence described here, do you think the plea deal was the smartest legal option available?
And the court has considered also the several letters, character letters that have been submitted on behalf of the defendant, which are 8. I see 8 in number. All right. Arguments by the parties. What are you asking for, please? State.
Judge, I think you know it's clear that I'm asking for the 15 years. I think that I feel for his mom, and I understand the pastor and what his girl is. But the real tell here is the conduct on this date in all of its entirety. Admittedly, Mr. Cunningham knows that he should have changed his conduct, which that's the problem is that you can't take back what these individuals experienced on this date of violence on June 18th. I can't even begin to imagine what that 4- and 1-year-old have thought since the incident. I agree with my complainants on the scenario, having talked with Mr. Barker as well as Ms. Brooks, and I think that they're absolutely right that it would be a mistake to give this man the second opportunity that he's asking for, that is in truth more than there. One of the other tales is that he's managed to keep conduct away from his mother that he was living with from the age of 15 when he was daily using marijuana. I think we've got a cleaned up version here today for your honor's benefit for the sentencing. But the other tale is his conduct that was in jail. 11 different reports, and he's auditioning for the court about whether or not he can follow rules. If he can't manage to not disrespect that staff in there, and you end up in fights, I would only ask for the protection of Jefferson County and sentence 15 years.
Says for how much?
15 years.
Go ahead.
There's no argument, Your Honor, in reference to what he did to two innocent people or two innocent families. What you see in the PSI report, though, is that there really isn't any criminal conduct after or before or after that in reference to the legal system. You have marijuana use in the U.S. Army, but wait a couple of years and probably marijuana use is going to be illegal in most states. But he was discharged not honorably. So what do you do with a kid that's doesn't know? And what we try to do today is to try to present a little bit, and I don't know whether it's a cleaned up version or not, but basically he grew up by himself. Mom seems like a decent person, but mom had to be able to support herself, and all her life he's had no dad, no one, not even financial support in reference to him. We realized through the questioning of the state that he had some abuse problems in Maryland from family members who took advantage of him. And then in the middle of all this was ripped from whatever persons that he had some type of relationship in his senior year in high school and sent to the outskirts of Chicago.
Let me ask you, as we work through this, the alleged sexual abuse problems by family members, what consequently happened to those family members as a result of it? Were they sanctioned in any way?
I don't know, Judge. I never asked, but we do know that he did, I guess, receive some type of counseling. But
I never heard what was
we can ask
brought formally for such a horrendous event.
Ms. Finningham. Please stand up and tell what happened to the uncle and the other family member.
What do you mean? Were they charged with something?
No.
Was it reported?
No.
Go ahead.
Even now, when he talks to the probation officer preparing the report, I think he was forthright in when he started marijuana, the synthetic marijuana, which is one time, which he says was at the date of the incident. But also what he was going through in reference to depression, anxiety, psychological and emotional, and asked, and which was probably one of the few times that I've seen, expressed a need for treatment for these conditions. You could put him on deferred, and he's looking at life. You can put him on deferred for one, find him for robbery on the other, send him because of maybe what he's done in county jail, and I could then file for shock probation if he corrected himself, if it was robbery. And keep him on the hook after that in reference to probation. We've got people, the pastor here, Pastor Matthews, and conditions, and as this court knows, the problem is I guess a lack of parental, but then it's also the lack of young people today not knowing what a gun and everything else gets you in the road that it goes down. There's nothing that says what he did is anything but terrorizing to two innocent families. They were minding their own business on that Saturday in June. But what do you do with someone that's so young with no criminal history that definitely has some problems somewhere so that he gets over it, but he has to learn. and he has to pay for it. He has not succeeded in life because he had, I guess, an opportunity in the Army, but at 18 years old, in the middle of nowhere in Fort Benning, Georgia, which I've been very young down there, it's very, I know we went through. But with that being said, we're asking the court, if it's not deferred probation, that you would consider deferred and something with a lesser included, to give them a taste of TDC and maybe a ride on a bus to Huntsville for a little bit of time to know what it's really like when you commit an offense that's going to, I guess, affect you the rest of your life. And then see, hopefully, if he does follow the rules and regulations there, that he's given that second chance and put back on under your supervision, and also with the help of his family and his church.
Any follow-up?
No.
All right. All right, evidence is before the court, and the court is going to make some findings of what are influencing the court's decision, as well as explaining why the court decides that the appropriate punishment is as follows. Criminal sanctions and penalties are essentially based upon two factors: the circumstances of the crime and criminal history. But there's also a third factor, and that is the life of a defendant. And here, what the court finds most compelling is that in the commission of this crime, it's already been pointed out that you assaulted two people, and both of them were threatened and in fear of their life by you, who has no authority to do that. You don't take God's will into your hands. And when you have a loaded firearm, and it was loaded, wasn't it?
No, sir, it was loaded.
I'm sorry. What did you just say to me?
It was loaded, Your Honor.
Sir?
It was not loaded, Your Honor.
You're looking at me, and I'm about to sentence you and make a decision, and you...
What an intense courtroom journey. In the first case, we watched a defendant accept responsibility through a negotiated plea involving serious felony charges, resulting in prison time, mandatory sex offender registration, and a final resolution that largely closed the door on future appeals. In the second proceeding, the focus shifted to violent robbery allegations, victim impact, and the difficult question of whether rehabilitation should outweigh punishment. Throughout both hearings, the judges repeatedly emphasized accountability, public safety, and the long-term consequences of criminal choices. These cases serve as powerful reminders that courtroom decisions aren't just about